Your documents come back. License in your hand. Warning in your hand. The officer steps back. You feel it. That physical release, the moment the stop appears to be over. You reach for your phone. You start thinking about where you were going. And then the officer leans back against your door and says, "Before you go, can I ask you something?" And just like that, the stop that was over is not over anymore. This is the most dangerous moment in any traffic stop. Not the initial approach, not the license check. This moment, after the documents are returned, after your guard has dropped completely, is when officers are trained to ask the questions that do the most damage. And it works every single time because drivers believe the hard part is behind them. The hard part just started. That phrase, "before you go," is not casual. It is a legal signal. It tells you that the officer knows the stop should be ending. He is asking anyway. And how you respond in the next 30 seconds determines whether you drive away clean or whether you hand law enforcement an open door into your vehicle, your story, and your life. This is educational content to help you understand your rights. For specific legal guidance, consult a licensed attorney in your jurisdiction. I have analyzed over 200 body cam recordings of this exact moment, the post-handback pivot, and studied every controlling Supreme Court case on extended stops, consent, and the voluntary nature of roadside questioning. I have identified 4 exact phrases that protect you the moment you hear "before you go." Most drivers have never heard any of them. After today, you will. Subscribe right now. In a few days, I am dropping the video on what to do when an officer says they smell something in your car. The #1 way a routine stop becomes an arrest. If you are not subscribed, you will not see it when you need it most. Stay calm. Stay polite. But understand what those 3 words are actually doing. Here are the 4 phrases every driver needs the moment an officer says "before you go." Phrase number 1. "Officer, you have returned my documents. Am I free to go right now?" Here is the mistake nearly every driver makes. The officer says "before you go" and the driver pauses, waits, listens to whatever comes next. In that pause, in that small cooperative silence, the driver has already extended the stop voluntarily. The encounter that should have ended is now alive again because the driver did not force the moment closed. Picture the scene. License back. Warning back. Officer steps back from the door, then back in. "Before you go, can I ask you something?" The driver thinks, the hard part is over. He says, "Yeah, what's up?" Body cam is recording. That "yeah, what's up" is the moment a defense attorney later points to and says, "This is where my client voluntarily continued the encounter." Here is what the law actually says. In Rodriguez versus United States, decided unanimously by the Supreme Court in 2015, the court ruled that a traffic stop cannot extend beyond the time necessary to complete its original purpose without independent reasonable suspicion of criminal activity. Once your documents are returned and the warning is issued, that legal purpose is complete. But in Ohio versus Robinette, the court held that officers have no obligation to inform you that you are free to leave before asking additional questions. They can keep standing there. They can make the encounter feel ongoing. Unless you force the question, nothing in the law requires them to tell you it is over. "Officer, you have returned my documents. Am I free to go right now?" Again. "Officer, you have returned my documents. Am I free to go right now?" One more time. "Officer, you have returned my documents. Am I free to go right now?" Flat tone, respectful, no edge. You are not challenging the officer. You are asking a binary legal question that must be answered on camera. Either you are free to go, in which case you go calmly with your hands visible without another word, or you are not free to go, in which case the officer has just claimed the authority to detain you further and must be able to legally justify that claim. The bottom line: the stop does not end until you make it end. The officer has no obligation to close it. You do. Phrase number 2. "I do not consent to any searches of my vehicle, my person, or my belongings." Here is the mistake. The officer confirms you are free to go and then immediately follows with, "Do you mind if I take a quick look in the car before you head out?" The driver, relieved they are technically free, feels the momentum of the interaction. The officer already knows they are not being detained. Saying no now feels strange, unnecessary, like it creates suspicion where none existed. So the driver says, "Sure, go ahead." That "sure, go ahead" just gave law enforcement a constitutionally valid consent search. Everything found inside is now admissible, whatever those items are, whatever they mean, whatever case they build. Here is what the law actually says. In Schneckloth versus Bustamante, The Supreme Court ruled that consent to search is constitutionally valid when given voluntarily, and that officers are not required to inform you of your right to refuse. They do not have to tell you that you can say no. If you consent without knowing you could refuse, that consent is still legally valid. Your yes is your yes regardless of whether you understood your no was an option. Defense attorneys use one line in court on this issue every single day. I do not consent to any searches of my vehicle, my person, or my belongings. Again, I do not consent to any searches of my vehicle, my person, or my belongings. One more time. I do not consent to any searches of my vehicle, my person, or my belongings. Calm. Clear. No explanation required. You do not need to justify a refusal. The sentence is the record. It tells the body cam, the prosecutor, and the judge that no voluntary consent was ever given, and that any search that followed required independent legal justification that had nothing to do with your permission. Refusing consent is not probable cause. It cannot be used as the sole basis for a search. The bottom line. The officer does not have to tell you that you can say no. You already know. Say it. Phrase number 3. I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. Here is the mistake. The officer pivots. You decline the search. He accepts it without visible reaction. Then he tries a different angle. So where are you headed tonight? Or, you seem a little nervous, everything okay? Or, you know this area well? It sounds like conversation. It is not conversation. It is a recorded statement collection attempt disguised as small talk. Here is what the law actually says. In Berkemer v. McCarty, decided unanimously by the Supreme Court in 1984, the court held that roadside questioning during a traffic stop constitutes a form of custodial interrogation for Fifth Amendment purposes, and that statements made voluntarily are admissible. Voluntarily is the controlling word. The moment you answer a casual follow-up question after a stop is technically complete, that answer belongs to the state. And in Salinas v. Texas, decided 5-4 in 2013, the court held that the Fifth Amendment is not self-executing. Silence alone does not invoke the privilege. Genevevo Salinas stayed quiet during police questioning before his arrest. Prosecutors used that silence against him at trial because Salinas never said the words out loud. The court held that the invocation must be explicit to be constitutionally recognized. Silence without the words is legally invisible. You have to say it. I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. Again, I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. One more time. I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. After that sentence, nothing else leaves your mouth. Not a clarification, not a softening statement, not a "you understand, officer, I just." The phrase stands alone. Any continued questioning after an explicit on-camera invocation creates a constitutionally problematic record for any prosecution that follows. The bottom line. Casual questions after a stop are not casual. Silence without the words is not protection. The words are the protection. Phrase number 4. Officer, I am going to go now. My hands will stay visible. Here is the mistake. Everything has gone right. You identified the end of the stop. You declined the search. You invoked your rights. The officer has no legal basis to hold you. And then he just keeps standing there, not saying you are free to go again, not saying you are being detained, just present, just watching. And the driver sits there waiting for a definitive signal that never comes, because the officer does not need to give one. Here is what the law actually says. In United States v. Mendenhall, the Supreme Court held that a person is seized within the meaning of the Fourth Amendment only if a reasonable person in the circumstances would not feel free to leave. The officer's physical presence, his proximity, his silence, the fact that he has not stepped away, can create the appearance of a continuing detention even when no formal one exists. If you sit there waiting, a court may interpret your continued presence as voluntary engagement. Under Rodriguez, the stop is over. Under Robinette, he does not have to tell you. Under Mendenhall, your behavior matters. Officer, I am going to go now. My hands will stay visible. Again. Officer, I am going to go now. My hands will stay visible. One more time. Officer, I am going to go now. My hands will stay visible. Then you go. Slowly. Hands visible on the wheel. Signal properly. Do not accelerate hard. Do not look back. You have created a clean record on body cam. A person who is deliberate, non-confrontational, legally informed, and who exercised every right available to them at every stage of the encounter. The bottom line: if the stop is over, leave. The officer's presence is not a legal order to stay. Here is what all 4 phrases look like together. Documents return. Officer leans back in. Before you go, can I ask you something? You say, Officer, you have returned my documents. Am I free to go right now? He says yes, but do you mind if I take a look in the car? You say, I do not consent to any searches of my vehicle, my person, or my belongings. He pivots. So where are you headed tonight? You say, I invoke my Fifth Amendment right to remain silent. I will not be answering any questions. He says nothing, just stands there. You say, Officer, I am going to go now. My hands will stay visible. And you leave. 4 phrases. The encounter is closed. This is educational content only and not legal advice. Laws vary by state. Always consult a qualified attorney in your jurisdiction for your specific situation. In a few days, I am dropping the video on what to do when an officer says they smell something in your car. One of the most abused claims in traffic stop history, and it ends in an arrest every day in situations where the driver had every right to drive away clean. Subscribe right now so you do not miss it. Smash the like button if this changed how you will handle that moment. Drop a comment. Have you ever heard before you go and just answered without thinking about it? I read every comment. Stay sharp. Know your rights.